The first matter to come before us this morning is U.S. Bank versus David Weber et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you would like to reserve that time as an appellant and let me know, I'm keeping track of the clock this morning to keep you apprised of the passage of time. We've read the briefs and we're ready to see when you are.
Good morning, Your Honors. My name is Brent English. I represent Shannon Poff, who is the appellant in this case, and I would like to reserve 3 minutes of my time for rebuttal. Your Honor, since you've read the briefs, you know that this is a foreclosure case that originated in Worcester, in Wayne County. My client was a co-mortgagor on a mortgage. She was served with a complaint. She filed an answer, and rather quickly after she filed her answer, after there was an intervening bankruptcy by David Weber, and relief from the state being granted, she filed her answer, and then quickly there was an, quote, amended motion for summary judgment, which was actually a motion for summary judgment directed at her. That motion was filed on April 21st, was received by me on April 23rd, and the local rule in Wayne County is that the court will set a date on which parties are to have a so-called non-oral hearing, and therefore your pleadings and any evidence in opposition to summary judgment must be filed at or before that date. The record is clear that although the court issued such an order on April 28th, it was never served upon me, and I was completely unaware of the date until I had a paralegal in my office check the docket because we weren't hearing what our response date was, and discovered that the court had issued an order establishing a response date from May 9th of 2014. Since we were obviously beyond our response date, and since the court had not yet acted on the motion for summary judgment, we filed a motion immediately in the trial court with appropriate affidavits indicating that we had not received notice. And then we determined that the notice had in fact been sent to an office address of mine that I exited in August of 2012. And although mail had been forwarded for a year pursuant to the postal code or the postal regulations, no more mail was being forwarded from there. In fact, that space was not occupied at all, so even if it had gone there, no one would have been able to accept it. We advised the court of that and asked for a short enlargement of time to actually file our brief in opposition with appropriate evidence challenging the motion for summary judgment. The court, although it had received that motion, although it was docketed on the court's docket.
What date was that motion docketed?
It was docketed May 28th of 2014. Okay. This was sent by Federal Express to the court just the day after we learned that this set of circumstances had occurred. The fact of the matter is that from the beginning of this case until the end of the case, my office address had obviously been listed on every pleading correctly, and that apparently the court had an old address, never checked its own computer system, or the clerk never did, and as a result, whatever this document was that had been sent, the notice of when the non-oral hearing would be was sent to the wrong address. In any event, the court granted the motion for summary judgment and then several days later denied the motion to extend time to file a brief in opposition to the motion for summary judgment. That entry, likewise, was not served on me, and in fact, it wasn't even shown in the electronic docket until we called and said, what is going on here, and found out that they had failed to, Wayne County has a system where they now image all pleadings, and they are available on a website. And when we were checking this website to find out what was actually going on, we learned that not only was it sent to the wrong address a second time, but that it was not even imaged and on the docket itself. So we got it imaged onto the docket, and then Shannon Poff filed her notice of appeal, which comes before the court.
And so, the denial of the enlargement of time, which was the motion for the enlargement of time was docketed on the 28th, the JE granting summary judgment was docketed on the 29th.
believe those are you looking at the docket?
I'm looking at the order that was attached. It's signed on the 29th. When was it docketed? The 30th, perhaps? So the judgment granting, summary judgment, granting foreclosure.
Yes, Your Honor. And a monetary judgment.
Yes.
On the note.
Right. Is signed by Judge Spittler on the 29th. One day after the motion for enlargement of time is docketed, based on your answer to the earlier question.
Yes, Your Honor.
What I don't see in here is the order denying, and because it's not the order of appeal, but what I don't see in here is the order denying the enlargement of time.
It was dated June 3rd.
And is it an order, or is it just a...
It's just a judgment entry saying, motion for enlargement of time denied. And I, of course, have it. I'm happy to provide it to the court.
Okay.
But it was not imaged on the website.
Okay.
And so, therefore, we didn't know about it. We ultimately didn't learn of it. And that's why we've indicated it in our brief.
Thank you.
Okay. So the first question in this case is whether or not the trial court erred and abused its discretion by not permitting by denying and not allowing an additional amount of time in light of the facts that we've identified. Civil Rule 6B, of course, permits the court to enlarge the time for doing any act other than filing a notice of appeal, and certain other acts that are expressly identified in Civil Rule 6B. The question, of course, is in this case whether the facts support a notion of excusable neglect. Under the law, as this court has clearly held and other courts, including the Supreme Court of Ohio, has held, that standard is relatively loose, particularly with respect to filing a late file pleading. However, there has to be some justification for doing so, and not only did we provide some justification, but in my opinion, compelling justification for giving us an opportunity to respond to this motion for summary judgment. So the first issue that I believe that the court should definitely consider is whether or not the trial court erred by not giving us the appropriate amount of time to respond to the motion for summary judgment. Even if the court were to determine that we had sufficient time, or this was not excusable neglect, or whatever the court's rationale might be, we respectfully submit that the court improperly granted summary judgment in this case. In this case, this is an interesting case, in as much as the lawsuit is brought by U.S. Bank. And U.S. Bank contends that it is, let me just quote this specifically, the trustee of Manufactured Housing Contract Senior Subordinate Pass-Through Certificate Trust 2000-6.
That is as clear as mud.
Yes, certainly, I have no idea what that means. And it was never explained in the record. They claim to be a trustee, and they claim to be an assignee of the note and the mortgage that Shannon Poff is alleged to have signed. Shannon Poff admitted in her answer that she signed the note. She denied all other allegations that were in the complaint. There is no assignment in this record of this note ever from the initial holder of the note, which was Conseco Financial Services. There is no evidence in this record that this was ever assigned to anyone, including and particularly U.S. Bank as trustee of Manufactured Housing Contract, etc.
What of the evidence that, or the statements that were contained within the preliminary judicial?
Your Honor, those are not part of the record for purposes of consideration of the motion for summary judgment. This is not something that was ever relied upon by U.S. Bank. It was not something that the court, at least ostensibly, relied upon. There is no indication whatsoever in the motion for summary judgment or in the affidavit that this assignment had been made and that U.S. Bank was the holder of the note in question. Now, I understand that they want to suggest that since it was in the preliminary judicial report that that's somehow a basis. However, Civil Rule 56C is very particular. It says you shall consider only specific evidence, including pleadings, admissions, and affidavits and deposition testimony. It does not say that you have a right to just rifle through a file and accept what some title company may or may not have accurately stated to be an assignment. And if there is a self-authenticating document that has to be identified, there's no evidence that there's any self-authenticating documents on which U.S. Bank relied. So the first issue in this case is whether or not there was ever an assignment at all. The second question is whether the mortgage itself shows any kind of an endorsement that was a transfer of this mortgage to U.S. Bank. And with respect to that, the mortgage itself, it's part of the file, is most interesting in as much as there is a purported assignment form at the end of the mortgage, the very last page of the mortgage. It says that Conseco hereby assigns to blank its interest under this mortgage, and anticipating that U.S. Bank would have contended, although it did not, that this was basically a transfer to bearer transfer. The fact of the matter was it's not signed. The assignment itself is not signed. So if there was an assignment pursuant to the mortgage, certainly it had to be signed, and the Uniform Commercial Code specifically requires that, and that was not done in this case. Now, admittedly, a mortgage and a note may be assigned by separate instrument. There's no question about that, and I'm not contending otherwise, but that is not part of the record evidence in this case. What we have is an affidavit from someone, I can't tell if it's a man or a woman, who simply says that the mortgage was assigned. But as the law is pretty clear that that is plainly hearsay, that he or she cannot make such a contention without having the relevant documents to establish that that individual did not indicate that he or she was a records custodian for U.S. Bank or for anyone else, including Green Tree Financial Services. He simply attempted to assert certain facts and then claimed that therefore U.S. Bank was entitled to foreclose this mortgage.
And you are just now reaching that 3 minutes of reserved rebuttal time.
Okay, let me buy back 1 minute and just say that with respect to the claim, there's a second claim here for a judgment on the note. And this note is particularly interesting in as much as it does not obligate either of the obligors under the note to make any payments on the note until a, quote, final disbursement is made. That's what the note says. Date of final disbursement or 21 days after final disbursement, whichever comes first. There is no evidence in this record that that, quote, final disbursement, whatever that means, was ever made in this case. And as a result, a condition precedent to establishing liability under the note has not been met. And therefore, I respectfully request that you reverse, that you find that the motion for summary judgment was not properly granted, that U.S. Bank did not comply with its obligations under Rule 56C, and that you remand for further proceedings. Thank you. I'll reserve whatever I have left.
May it please the court. My name is David DeMars. I represent U.S. Bank. In answer to Judge Henschel's question, I have a copy of the judgment entry if anybody wants to see it. It's June 3rd. It's 2 lines where and it just says, this matter is before the court on defendant's motion for leave to file a brief in opposition to plaintiff's amended motion for summary judgment and motion for enlargement of time to file a brief in opposition to plaintiff's amended motion for summary judgment. After due consideration, defendant's motions are denied. That was all that Judge Spitler had said on that. With respect to all of counsel's statements, I think many of which now are moot as a little more history for the court. After the judgment entry went on, the property was scheduled for sale. The property did sell at foreclosure sale on August 20th, 2014. It sold to a third-party buyer. The property was appraised for $82,000. It sold for, I believe, $74,000. The sale was confirmed. Title was transferred over to the third party. There was no bond posted with respect to this matter, so the actions of the court with respect to the entry confirming sale took place, and third-party buyers now in possession and title owner to the property. I think what we're really talking about in this case is did the trial court abuse its discretion in denying the plaintiff's or the defendant's POF's motion for enlargement of time. I don't think that Ms. POF, the defendant, has shown that the judge was unreasonable, arbitrary, or unconscionable. What we do have here in the record is we show that the motion for summary judgment was filed. It was served properly on defense counsel in April of 2014. There's no denying that. He doesn't deny that he received it by the most generous local rule in the state of Ohio is you're going to get 30 days to reply to a motion for summary judgment, or local rule, or the court's going to schedule a non-oral hearing. What the facts in this case show is that much later than the 30 days, so much later than 30 days plus 3 days for delivery by mail, action was taken by Ms. POF to respond to the motion for summary judgment. By that time, not only had 30 days, more than 30 days elapsed, but almost 2 weeks had elapsed when the court had issued an order giving counsel for the defendant time to respond to the motion for summary judgment. The age we live in, when I first started practicing law, you got everything in the mail. There was no electronic service. Today, it's much different. That there are electronic, there are dockets. We can jump online, check and see to make sure something was filed. There was no doubt that in this case, the motion for summary judgment was filed. There is no doubt that there's a response deadline under the Ohio Rules of Civil Procedure to respond to a motion for summary judgment if local rule or the court doesn't issue otherwise. That would be 30 days. That didn't happen in this case. And it was well beyond even that time. We're approaching 40 days before any action was taken. And we can sit there and second guess the trial court and say, yeah, he should, but the standard that this court has to apply is, did the judge abuse his discretion in saying no and deny the motion? And I think he's failed to demonstrate that what Judge Spittler did was unreasonable, arbitrary, or unconscionable. He denied the motion. He said, based on what you provided to me and what you told me, I'm denying your motion for enlargement of time. And I think until he gets over that hurdle, there is no second issue in this case. He can't demonstrate that what Judge Spittler did abused his discretion in denying the motion. Furthermore, and I'll just jump ahead to the second issue, we're hearing a lot of challenge, and I'm sure this court's ad nauseum dealing with foreclosure cases, and that's rather unfortunate. And the Schwartzwald decision didn't clear up many of the areas, or what the Supreme Court hoped, and they recently issued the case of Wells Fargo versus Horn, which said it's not what's filed at the time, it's what can you prove that you were the holder of the note. And Greentree, or U.S. Bank, Greentree, the servicer for U.S. Bank, provided an affidavit. They had an ample opportunity to object to that. They didn't. And I think it's really important. There's not a district court of appeals in the state of Ohio that has said that the borrower can challenge any assignment of mortgage, or they don't have standing to do that. And that's exactly, in this case, what the defendant POF is attempting to do. She's attempting to challenge something that she has no standing to challenge. And I don't want to get, I'm sure the court has heard that argument on numerous occasions. It's in every district court in Ohio. Courts have come out and said the defendant borrower does not have standing to attack an assignment of mortgage or endorsements, because they weren't party to those agreements. So therefore they lack standing to challenge them. And that's if the court can get over, even find that Judge Spittler abused his discretion, they still have to say that the defendant, has standing to challenge that, and they don't.
Well, they're just saying it's the wrong party. They don't think there's no evidence of who the party is.
No, they don't have standing because they weren't a party to that transaction, whether it be U.S. Bank, Greentree, Chase, whoever it is. They weren't weren't a party to the assignment of the mortgage and the note, so therefore they have no standing to challenge that. The only entities that could challenge that would be the two parties that entered into it.
I guess I'm not hearing them challenging, they're not using any standard to try to challenge it, they're just saying you haven't established that who you are. All we're asking is show us who you are, not how did you get there.
And I don't think it even matters if you get there. They can't ask that question.
Well, if it's the wrong party defendant or plaintiff, then...
Well, the documentation submitted to the trial court demonstrated that the proper party was U.S. Bank. Absent that, they would need to bring in something that says, you're not, and here's why.
And the document would only be what it says on its face. You're saying the documentation in the record demonstrates it is had received an assignment of the note and mortgage.
That's correct.
So that is taken at face value under your position.
Correct. Correct. So we believe that, first of all, you never get to the second argument that they make in their brief, which is the issue of summary judgment, because I don't think they've demonstrated that the trial court abused its discretion in denying the motion, their motion for an enlargement of time. Be happy to answer any questions. If not, it's U.S. Bank's position that the decision of the trial court should stand. Thank you.
Counsel, you have just over 2 minutes remaining.
Thank you, Your Honor. Well, that is a most interesting argument that has just been made. You are correct, Your Honor, that I have not challenged the standing to make an assignment. What I have challenged is that there is no evidence in the record that an assignment was ever made. It's one thing to say somebody assigned it as a contention in a pleading, and when you deny that for summary judgment purposes, you have to establish that in fact there was an assignment. That's what they have not established with any competent evidence whatsoever. And even if you were to find, although I don't think you should, that there has not been a demonstration of excusable neglect, that does not mean that you cannot consider the question that is raised in the second assignment of error, which is that the motion for summary judgment was improperly granted. With respect to the foreclosure, we agree that the property has been sold. That is not the issue. But what we really have in this case, ultimately, is we have a finding based upon the foreclosure that my client specifically owes U.S. Bank something like $124,000 plus interest and some unknown late fees, which raises a question about whether this is even a final appealable order. In any event, the facts are that on April 23rd we received this motion. The court gave us until May 9th, never told us about it. And it's one thing to say, well, it's well and good. When I started practicing law, you got a note from the court as to what you were supposed to do. But that's the way the court works. That's the way the Wayne County Court of Common Pleas works. That's the way the Court of Appeals works. We have dockets and we have orders. And parties get served with orders. And when a party doesn't get the order, it would strike me that it is pretty basic, that is excusable neglect for not responding to an order. If you don't know about it, you don't know what to do. And this idea that somehow we should have known that there was this mystical 30-day time period when the local rule says the court will establish a date. It doesn't say it will be within 30 days or 40 days or 60 days. It says the court will establish a date and will tell you what that date is. When the court established a date and didn't tell us what the date was, that is where the problem is. U.S. Bank doesn't challenge that.
So you're saying, even though the rules say 30 days, you are entitled to wait longer until the court issues a notice or a date? In
my reply brief, I quoted the local rule, and specifically what it says. Let me just read it to you quickly. Local Rule 4C1 of the Wayne County Court of Common Pleas provides, quote, motions for summary judgment will be decided without oral hearing unless oral argument is requested and determined necessary by the court. Upon the filing of the motion, the court will fix a hearing date as required by Rule 56C of the Rules of Civil Procedure using the form journal entry marked as Exhibit B and attached to these rules. So, your date for responding in that court, and it's different in lots of courts. Some courts have a standing rule, Cuyahoga County, 30 days. Lorain County, typically 21 days, although it's...
So you don't have to do anything until that date?
That's correct.
You don't have to respond to the motion or whatever?
Well, you must, if you're going to respond to the motion, you must respond by the date of the non-oral hearing.
Right, which could be longer than the rule that says 30 days.
Which rule are you referring to?
Well,
because there is no rule in Wayne County that says 30 days.
All right, that's where I'm trying to figure out.
Okay, I know that was suggested that in some other courts there's a 30-day rule, and I just said, and there are, the Cuyahoga County Local Rule 11B says that opposition shall be filed to a motion for summary judgment within 30 days of the date of receipt of the motion for summary judgment. That gives you a finite period. Lorain County says, of course part of the 9th Appellate District, 21 days from the date of filing the motion. In Wayne County, it says there's no specific date. It's the date affixed, will fix a hearing date, and that's the date for the non-oral hearing. Okay. I ask you to reverse.
Thank you. Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision which we mailed to both sides as well as posted on the Ohio Supreme Court website. Thank you. We are adjourned.